Hi, everyone, and welcome to the Hospice Care of the Low Country webinar on advanced care planning. My name is Debbie Lines. I'm going to be your moderator today. I'm very excited to have everyone here. And as people are joining us, we thought we'd tell you a little bit about what we're going to do today. We are going to have Lisa McCray talk to us about legal matters. I'm really excited about this. In the meantime, we're going to wait for everyone, but we're going to do something a little bit different because we want to get to know you. We've got some questions to ask you on a poll that you'll be able to see. And we are going to ask you those questions. You will answer. And then the chair of Hospice Care of the Low Country, Janet Porter, is going to reveal and share with us the results of the poll. So Janet, I would love to have you join me. And let's do this first question.
Hi, Debbie. How are you this morning?
I am wonderful. And we've had a chance to sort of chat, and it's been interesting that this is a very pertinent conversation.
Yes. Oh, it's so timely. Elise is going to talk more about this in a few minutes, and we're so glad she's joining us today. But, she's going to talk about how much demand she's had for her services since COVID hit because people have extra time, but also because, end of life questions are more top of mind with people than they normally are when you're living your busy life. And so this topic is so timely, and hopefully we'll answer a lot of questions for people today.
What we're going to do, I think, Janet, is let's get our first poll question. And what we'd love everyone to do is it's a yes or no question. The first question is, do you have a living will?
So I think what we need to explain a little bit is that what people need to do is
basically go on and you'll see, do you have a healthcare power of attorney? It's really, do you have a living will is what we want to know. And you'll just answer yes or no. We'll keep
here you
the
go.
poll.
Here's the question. Do you have a living will, Debbie? There you go.
Right. Do you have a living will? And you'll answer yes or no. Just push on the button.
Right. All you have to do is go up to we see some people answering to go up to yes, no, and just click right on that and that'll show up. And after a few minutes here, a few seconds here, we'll give you the results. Also, if you're interested, we're also have a chat. So if you have any problems getting on or anything, make sure that you go over to the chat. On your toolbar below, there's a chat feature, and you can click on that and ask any of us a question. And Darlene Schutz is going to be reporting on it, is going to be telling everybody what the questions are people have. So Debbie, we have the results.
Oh, yes, ma'am. I'm dying to hear this.
And of the participants on right now, 3/4, 75% are saying that they do have a living will, and one person said they do not. Whether you have a living will or not, for the whole audience, we're going to be answering some questions today that are going to give them some more information about their living will. So the people who have it may find they want to do some revisions. And I'm going to talk a little bit about how my husband and I decided to revise ours. So whether you have one or not, this should be helpful to you today.
And as people are joining, Janet, we'd like to welcome them all to the Hospice Care of the Low Country webinar on advanced care planning. This is the second in a series of webinars we're really excited to bring to you. And what we're doing as people are joining is we have some poll questions. I think that will kind of get us all in the spirit of what a Zoom webinar is. It's really interactive and a wonderful opportunity to ask questions. As Janet was sharing, there is a chat bar if you have some questions. We'd like to ask our second poll question right now if we can. And that is, does your living will address whether you would like to be placed on a ventilator? All you have to do is answer yes or no. And then Janet's going to review with us what the results are. So we'll take about 10 seconds. And I think, Janet, like you share all the time in this time of COVID-19, it's a perfectly apropos question and one that many of us are thinking about and talking about. And we hadn't really thought about it before.
Yes, Debbie. So the results are interesting. 50% of those who answered indicated that their living will does address being placed on a ventilator.
Ah,
Then 17% said they don't know. 17% said no, it does not address it. And the balance, another 33%, said they're not sure. So Elisa's going to inform us about how many people are asking her these kinds of questions, particularly because of the reports that are going on about how hard it is to get people off ventilators with COVID who are in the ICUs. There's about a 75% death rate from people who go on ventilators in ICUs. And so the survival rate is not good. And that's causing questions like traditionally living wills cover feeding tubes and
yeah.
DNRs. They haven't traditionally really covered this question of a ventilator. So we'll get into that more with Elisa in just a few minutes.
I tell you, it's one of the topics where the more you know, the more questions that you have. Again, Janet Porter is here. She's the chairperson of Hospice Care of the Low Country. I'm Debbie Lyons. I'm your moderator today for this webinar from Hospice Care of the Low Country on advanced directives. And this specifically is on legal matters. Elisa McCray is an attorney, and she is going to share with us a really interesting perspective and I think answer a lot of our questions. Right now, what we're doing is trying to get you, the audience, get to know you better. This is going to be our third question. It's a poll question. Do you have or have you specified who you want to have as your healthcare power of attorney? Do you know or have you specified who is going to be your healthcare power of attorney? Janet, I'm really curious about this one also. Please, on the box, you just simply check yes or no. And again, we're doing this poll to get to know you better before our actual webinar begins so that we can allow everyone to come in and feel part of this.
So Debbie, our results are that 92% of the audience, which are very well prepared, actually now we're just changing a little bit, 86% of the audience have a healthcare power of attorney, 7% don't know, and 7% say no, it does not. So, and just like the other questions, whether you have a healthcare power of attorney or not, you're going to find in this process that you're going to be informed by Elisa today about some aspects of choosing a healthcare power of attorney that even if you have one, might change your mind about who you picked. And I know in my family, I have sisters, and I know my sisters have made choices to go with one sister versus another based on geographic proximity, based on their health status. I mean, that's something that, doesn't necessarily remain fixed over time. So I think Elisa will illuminate us more on this topic in just a few minutes.
I think it's really an interesting topic, and it's so timely. It's about 1 minute until 10 o'clock. It's about 9:59. So we're going to get started in just a couple of minutes. We want to make sure that everyone has had the opportunity to join in on this Zoom webinar. I think that this is a new format for many of us. And I've been surprised, Janet, at how receptive and really interactive it can be to be able to participate like this from the comfort of our own homes. I find it's really a nice way to do it.
It is a nice way to do it, and we want to express appreciation to people for welcoming us into their homes. This is a way today to get informed and educated about topics that we just didn't conceive of, 3 or 4 months ago. So, Debbie, I'm going to let you start the webinar, and thank you very much for all of our participants to answering some questions. And hopefully we'll give you great information that will help you on all those questions.
Hi, once again, I'm Debbie Lyons, and I am your moderator for the second webinar that is brought to you by Hospice Care of the Low Country on advanced care planning. Today, we're going to be talking about legal matters, and we're going to be talking with Elisa McCray of Olivetti McCray and Withrow. Hospice Care in the Low Country began to offer these webinars, and we're doing a series of 4. They're very informative. It's an opportunity to interact and ask questions that many of us have had. And especially since the COVID-19, I think things are becoming very front and center. If this is your first Zoom call, or if, like me, it's not your first Zoom call, but you still like to have some clarity about how it all works. If you look in the bottom of your toolbar, okay, there is an icon that says chat. And that's going to be our way of answering questions that you may have. It's really effective, and it's a wonderful way to be able to interact and participate. If you click that icon, Darlene Schutz from Hospice Care of the Low Country is going to round them all up and filter them in, so we make sure that everything is going to flow smoothly and you'll get your question answered. Hospice Care of the Low Country has supported patients and families at the end of care, at the end of life, for over 38 years. Jenny Brazington has been the executive director for over 10 years. She is a valued member, not only of Hospice Care of the Low Country, but also our community. She's had a long nursing career. And whenever we talk to her, we share that it's been 20 years. No, it's been 30 years, and the years keep going on, and she loves it even more. She was an inpatient nurse, a critical care nurse, and a hospice nurse. She and her husband have lived here for 25 years from Pennsylvania. So Jenny, I would like to have you join us, and let's talk.
Hi, Debbie. How are you this morning?
Wonderful.
Great, great. Well, thank you everyone for joining us for our second webinar on advanced care planning. As it has been said, we're talking about legal matters today. And we feel that these subjects are so important to us, our community, our friends, our families, and especially during this time of COVID. As Janet and Debbie have already said, we're all thinking about that and what we need to do, and maybe what we decided 5 years ago is not pertinent to what's going on today. But Hospice Care of the Low Country, as many of you know, take care of people at end of life. Terminal illness, we not only take care of the patient, but their family. We do that with a team of professionals, doctors, nurses, social workers, counselors, and therapists. But when we bring someone onto our service, one of the things we ask them, other than their medical history and their emotional and spiritual and what their culture is and their beliefs and all that, is, do you have a living will, and have you chosen someone to be your power of attorney? Very important to all of us, and we encourage you to do this while you're of sound mind, while you're healthy, while you can make those choices of what you want and what you don't want. It is very important at end of life, because we need to know who that person is that's going to carry out your wishes. And that can be one person or two people, and it can change over the years. So we're here today to talk about all of that, answer your questions, get you to think about it, and maybe after this, go home and talk to your spouse or your sibling or your parent and say, hey, we really need to do this. So thank you again all for joining us today, and I hope we all can learn something. And I'm going to turn this back over to Janet Porter, who's the chairwoman of our board. Janet?
Thank you so much, Jenny. And before we go on, I just want to acknowledge the tremendous contribution that Darlene Schutz has made, who's our Director of Community Relations at the hospice, to organize all of these webinars, and the contribution that Debbie Lines is making as a terrific, I think, lifelong almost volunteer for us. She'll be our moderator for all of our series. So we've been mentioning on this video that what we're going to be talking today is about legal matters. And what I want to mention is that legal matters are not what's the only important issue at end of life. You know, our first webinar was on having the conversation. And we recognize at hospice that one of the most important things is for people to really answer the question, what matters to you? And we talked last time about the fact that that might be reconciling with your brother. It might be getting to your grandson's graduation. It might be, knowing what's going to, happen to your pets, to your, favorite dog. My dog, Oscar, I worry about, right? So it's a broad question of what matters to you at end of life. But one of the things that matters to you is your ability to control decision making should you in some way become incapacitated. And what also matters to you is what's going to happen to your assets, your $5,000 nest egg that you want to make sure goes to your cousin, or whatever assets you have, precious pieces of jewelry or china. So Elisa McCray is going to be joining us today to talk about those issues and to also talk about the issues related to medical care. So not only distribution of your assets, but those questions that might be in your mind about if I really, am, in a medically, and if I'm in a coma and non-responsive and have brain damage, do I want to be put on a ventilator? Do I want to have a feeding tube? Do I want to have a do not resuscitate order? So those medical questions today too will answer. So we're joined today by Elisa McCray of Olivetti, McCray and Withrow, and she specializes in estate planning and has been doing that in the Low Country for many years. She's a graduate of University of West Virginia Law School and has practiced in the Low Country for 13 years now. She's also licensed to practice both in Georgia and in South Carolina. Before I welcome Elisa, I want to remind you about the chat feature. Please send us your comments or questions. And so now, Elisa, please join us.
Good morning. Thank you so much, Janet.
Good morning, Elisa. It's great to see you.
Thank
so
you.
Let's start by telling us a little bit about you and how you got into estate planning, and what was it that drove you to practice this type of law? Tell us about that.
Sure. So one of the things when I was attending law school, I took the estate planning course my second year, the first semester, and no one in my family had ever talked about these things before. So it was really kind of this whole new world for me that I was very drawn to. I've always been interested in the financial aspects of things. And so this was just something for me that really clicked and it resonated with me. I've also, for a while, I thought I'd get a PhD and teach. And so the teaching aspects of it were really great as well, because I do feel like I get to spend a lot of time working with clients and educating them on what their options are so they can make an informed decision for their individual families.
Excellent. And so tell us a little bit then about the type of clients that you have. Do you have clients across the age spectrum?
I do. I will work obviously with any number of clients, and I tell people all the time, myself being, I have young children, ages 2 and 6, you just have to have a will, right? You have to have some kind of protection when you've got children. So I certainly work with people as young as being in their 20s to people who are really even in their late teens. Once they turn 18, I've done healthcare powers of attorney and durable powers of attorney for those people, because really as an adult, you want to have this protection and have these documents in place. But the vast majority of my clients are retired. Most of them are from somewhere else and they've retired here to the beautiful Low Country. And so we spend time talking about where their children are and then making sure that their documents are updated for South Carolina and that they have all the required or, the best practices type of documents in place.
So you just mentioned, I think, a key question for people who relocate here. You said that they're updated for South Carolina. Let's suppose you have all your documents, your will and everything, and you're from Ohio. Is it required when you move to a new state that you develop a new will? Or so talk to us about what that means to need to be updated for South Carolina.
Sure. So what we'll find a lot of the time is that revocable trusts and wills are often good from state to state. So we don't always necessarily have to make a change just based on the fact that you've moved. There are some things you may want to change based on the fact that you have moved. So I definitely think it makes sense to have those reviewed anytime you relocate to a new state. But one of the things that many people are surprised to learn is that your ancillary documents or the powers of attorney and the documents that in some cases are much more important than wills and trusts because they affect you while you're living, which are your durable power of attorney and your healthcare power of attorney and your living will. Those documents, the healthcare or advance directive documents, are going to be different in all 50 states. So each of the 50 states have a different code section or law that's going to affect how those are created. So you want to be cautious there that, again, if you relocate, you certainly want to have documents for the state you're living in. And each state has its own requirements for what will constitute a durable power of attorney. Sometimes people call that a general power of attorney or a financial power of attorney. But those documents as well are different in all 50 states.
Okay, excellent. So let's start with, what are the questions people typically come to you with, at the onset? Let's say somebody is for the first time thinking about having a will, having a power of attorney. What are the questions they come to you with primarily?
Sure. So I get questions across the board, and typically I would say the most often asked question is, do I need a revocable trust, or do I just want to have a simple will, or, a big structure issues. How do we want to handle the transfer of assets in the estate? But from a healthcare perspective and what we're talking about today, I think I get a lot of questions about these documents and how they're used in South Carolina. And I know we'll get into this, but our advanced directive system of having a living will and a healthcare power of attorney is very different from a lot of other states. And frankly, it's a little antiquated. So most states have gone to a really nice advanced directive, which is something that is readable and user-friendly. You mentioned I'm licensed in Georgia as well. They changed this around, I believe it was 2012 or 13, and have again, a great advanced directive now. We are still working with a bit of an antiquated system. So I do in this arena spend a lot of time talking about our healthcare documents and how you can complete those so that you are actually getting what you want. And I find that from all the other states documents I've ever looked at, I think ours are probably the most confusing and likely the easiest to sort of do it wrong and to not get the outcome that you want if you're trying to fill these out on your own.
So, Elisa, let's try to unpack, because you're using a lot of different words: durable power of attorney, healthcare power of attorney. So let's kind of unpack this.
Sure.
So I think people generally know what a will is. So, I think the common definition of a will is that it's what describes how you want your assets to just distributed. Is there any other explanation you want to give about what having just a will is?
No, I think you've taken care of that. What is, I want to make very clear, is a will does not become invoked, let's say, or become active until after the time that you've passed away. So I do have some people say, well, I'm named as this person's personal representative, or I'm named as the executor. We want to be clear that that has no bearing whatsoever while that person is alive. So a will is a document that strictly will come into play after you have passed away. It will be sent to the probate court. A judge will review it. And then if there's an executor that's needed to be named, they will appoint that person. And that person is then responsible for distributing your property and assets in accordance with what that document says.
Thank you for clarifying that. I haven't actually thought about it that way. So we think about a will, and people tend to know what that means. But then we also use interchangeably the word living will and you've used the word advanced directives. So I'm a hospital administrator, and the term that I use in vernacular is advanced directives. But my husband always corrects me and says, Janet, people don't think of it as advanced directives. The common thing is to think of it as a living will. So that term is the same thing. And talk about what a living will addresses, and then we'll get to the power of attorney part.
Sounds good. So a living will in this state is really a pretty basic document if you've ever taken a look at it. It's the basis of it is giving the meat and potatoes of the document is one page that's going to say, if you are in a terminal condition and likely to die within a reasonably short time, you can direct that nutrition and hydration either be provided or not be provided. And then you have those same two options if you're in a vegetative or persistent vegetative state or permanently unconscious. So that's really what the living will is designed to cover: a true end of life decision once you have already been declared by two physicians as terminally ill and likely to die within a reasonably short time, or in a persistent vegetative state / permanently unconscious.
And I have to say, as again, as a healthcare professional, that healthcare professionals desperately want to honor a patient's wishes. and how hard that is to do if there isn't a document that describes it, or even if there is a document, but the family members end up disagreeing at the bedside. It makes it so complicated for everyone to do the right thing about what the person really wishes. And one of the things we want at end of life, I think, is control. We want to be able to feel like we still have control over what happens for us, not to us, but for us, right? So a living will or advance directives really help with that. And we're going to be talking next time. I just want to mention, Elisa, while we have a break here, a little thought here is that we're going to be talking about medical matters next time. And we're going to be getting some tips on what to do to interface with when you call 911. And, I know one of the tips they're going to be talking about is having a plastic bag by your front door that you keep that has information about your insurance coverage, information about your medications, but also that living will and advance directive so that you can just grab it with you when, your husband falls off a ladder or something. So we'll talk more about that at our upcoming webinar, and we hope you'll attend. But let's go now to the other documents that are of interest, which is you mentioned a power of attorney, healthcare power of attorney, and then a durable power of attorney. So describe those two documents and what their differences are, Elisa.
Sure. Let's break those down because I find this to be an extremely important distinction. These documents, like I said, for many clients, these are more important than your will because you may have all of your assets set up to automatically transfer to someone at the time you die. You may not have things that are passing through a true will and going through probate court. But these documents, this durable power of attorney and healthcare power of attorney, these are affecting you while you are alive. And to just continue on with that distinction that we made before, on the flip side of sometimes after someone dies, I get the person that calls and they say, but I'm the power of attorney. And I say, well, the power of attorney ends at the moment of death. And you can think about this for both your durable power of attorney and your healthcare power of attorney. These are simply authorizations that you are giving to another person. And once you're deceased, your ability to give that authorization is now gone. And so these completely end the moment you pass away. So I want everyone to understand that at the forefront, that these are strictly going to apply to you while you are living. And there's can be overlap there, which becomes important for your greater estate plan. But let's talk, since today's idea, right, we're talking about advanced directives and how this affects you with your medical care. Both of these documents can affect you. So your durable power of attorney, I think of this as your life management document. This is the one that is going to affect check writing ability, management of your assets. This is the document that a nursing home is going to ask for someone to be able to check you in. An assisted living facility, if you're not competent, they're going to want to know, who can I call? Who is the person you've nominated as your agent to talk to? And this is the person who, again, will make those decisions on where you live, where's your residency, what state do you live in? Are your children going to move you back to Ohio? They're going to write the checks for you, like I said, make different arrangements for your financial obligations depending on how you have things titled. So there's a lot. I mean, these are designed to be extremely broad documents, and they can encompass a whole lot of different things. Your healthcare power of attorney is a lot more limited in the sense that it's only going to apply to making healthcare decisions if you are not able to voice them for yourself. So if I'm laying in a hospital bed and I'm still able to say, I don't want that treatment, they're going to listen to me, right? If I'm competent to make that decision, then they're going to listen to me. But if I'm comatose or if I'm just not competent at this point to make the decision, then at that point, your agent will kick in under your healthcare power of attorney. Please remember that these two people will work together. And often I see documents where they're not the same person. That's okay. But just know that if they're not going to be the same person, they need to know who the other one is. Because remember, if your healthcare power of attorney agent is authorizing, for instance, a health decision that your durable power of attorney agent is going to have to pay for, there's got to be some overlap there. They need to understand how to work together and how all this will be taken care of. If you do not have these documents, I think this is the last thing I'll really point out on this to be clear. Having these in place is how you avoid a guardianship and conservatorship. So I get a lot of questions as well. Someone will say, well, I need a guardianship for my mom. Well, if you have a healthcare power of attorney in South Carolina, you really shouldn't need a guardianship for your mom. And in fact, our judge here, who is wonderful, that handles these guardianship and conservatorship matters, she really, really emphasizes that we want to have these documents in place and hates to see cases come in when they have them, because these documents are designed to save you that hassle. So if there's one tip I'll pass along now, if you have not done these documents, this is the best bang for your buck in any kind of legal setting I have ever seen, because the cost of setting these up is so small. Even doing them with an attorney, having them done right, is so small compared to what you would pay if someone had to get a guardianship and conservatorship for you, which and now under South Carolina law as of last year requires that 3 different attorneys be involved. So just cha-ching, 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 you know, we have to have a court hearing. And so these actions can take months and months and months, and sometimes longer if they're contested, and can get very, very expensive. So again, healthcare power of attorney, living will, durable power of attorney, make sure those are on the top of your list of things to take care of.
Okay, excellent. So before we go on, I want, Elisa, I want to take a couple questions from the audience. So Lori asks, she says, at some point I'd be interested in hearing what I can do now that I'm healthy concerning a DNR. So let's talk about that. And then we have a question from Ashley, and we'll ask that, we'll answer that right after this one.
Sure. So a great question, because I get this a lot as well. The distinction with a DNR is that's something that if you're healthy, you actually can't get. So a true do not resuscitate order, and this gets confused a lot with a living will, but a true do not resuscitate order is something that's only going to be issued if you have been designated as terminally ill and a South Carolina licensed physician has signed off on that order.
Okay. Okay. So Lori what should she do now that she's healthy about a DNR?
She can't actually have a DNR at this point, but she definitely wants to make sure that she gets a living will and a healthcare power of attorney in place for South Carolina. She can appoint an agent under those documents, and she can make sure that the agent understands that if she ever becomes terminally ill, that she wants a DNR to be signed.
Okay. Okay. So Ashley asks, please address what legal steps you could recommend if you are facing a dementia diagnosis.
Sure. So it depends on dementia is a big spectrum, right? And so there's a point where you can no longer sign documents. And so this is something where I've met with clients before where I've had to say, it's just too late. We can't prepare those documents because this person's already been, the doctor has already stated they're not capable of signing financial paperwork. If there's a question involved, sometimes we will ask to get a statement from their doctor on whether or not they are competent to sign paperwork. So the earlier in the process of dementia that you complete this kind of paperwork outlining what you want, the better. Because if I think of dementia as kind of a 1 to 10 spectrum, right? You don't want to get too far along before you may not be able to sign anything anymore. So that's my first thing is, if this is a spouse or a loved one, get them seen right away by an attorney, by maybe their physician if you need to, depending on how severe it is at this point. But I would really encourage you to try to get those things, all the legal documents taken care of. You can address, there are all kinds of other matters that can come from Medicaid and long-term care planning and things that are outside the scope of today's conversation, but you would want to get all of those addressed, I think, at this outset of the dementia diagnosis.
So let's help Ashley out a little bit more. Darlene is going to be putting up, who's monitoring our chat today, is going to be putting up and reminding you what our website is at Hospice Care of the Lowcountry. And on that website, we have information from all of the webinars we're doing, all kinds of resources. And from our last webinar on having the conversation, we had somebody from a national organization called the Conversation Project, who was a guest of ours. And the Conversation Project is committed to stimulating people having conversations with their loved one about what matters to you and what their wishes are at end of life. And they have what they call toolkits, which are really like little brochures. And they have one just for regular people, right? But they do have a toolkit for how to have the conversation with somebody with dementia. If you think your mom is slipping and you want to have that conversation with her, what the steps are you need to go there. They even have a toolkit for how to face this discussion about death and dying with children. So they have a bunch of different resources, and that information is all available on our website. And Darlene has just put up the link to that website. But even if you still can't find it for potentially on the website, give us a call. Our phone number is on the link, and we're committed to making sure people's wishes are managed at end of life, whether they're a patient of ours at Hospice Care Lowcountry or not. And the number is 843-706-2296. And I'm just trying to see how my contacts work here. So think about using us as a resource, because we want to be a resource for the community in many more ways than just the on-site care we're providing. And I should mention, in terms of resources, that we also are doing a session, an upcoming webinar on grieving and loss. And we have grief support groups that are very active, particularly during COVID. We're doing them over the internet. We're doing them on Zoom, and people are anxious because, they're isolated, and grief is horrible when you're isolated and you're not active, right? I mean, it's horrible anytime, but it's really horrible when you're really facing it by yourself. And so those groups are very active. And so we're going to have an upcoming webinar to talk about that also, and we'll provide some resources there. So I also have a comment from Lissa, and Elisa says we might talk about a DNR document. Do you want to comment on that?
Again, I'll just say the DNR is something that you cannot get in South Carolina unless you have already been designated by a South Carolina licensed physician as terminally ill. So if you are working with hospice, these are routinely done. You can comment on that, Janet, if you want, but my understanding is these are routinely done when you're entering into hospice, because that's the whole goal here, is that you're able to be given comfort care and pass away peacefully and not resuscitated. A DNR is encompassing, what do you want to have happen? Do you want those paddles to be used and, shocked back to life? States all handle this differently. And in South Carolina, our legislature basically is, because these are state issued forms, that we've taken the position that if I'm a healthy, whatever aged person, and I'm running down the street and I have a heart attack, I don't have the option in this state to have a document that states I do not want to be resuscitated at that point, because I was otherwise not designated as terminally ill going in. And I do understand, I'm not licensed in a lot of the northeastern states, but I do understand that a lot of the states that are adopting right to die laws, I believe Oregon, Pennsylvania was one I've heard thrown around, that some of those states it's completely different, and they do allow you to have one at an earlier time. But here, just know that the DNR is not available to you unless you are otherwise declared by a doctor as terminally ill.
So Elisa, I want to respond to a comment you made. Part of our intake process, when we intake a patient into hospice, and we do that at all the different stages. We have patients that are with us for 6 months which is the designation Medicare requires that you have a diagnosis that leads the doctor to believe that you have 6 months or less to live. But we have patients who get recertified because they actually do well on hospice care. But part of our intake is to ask those questions, and then to make sure during the process they're updated. When we have a patient who's with us for some time, we go back and revisit and make sure everything's honored. So I also want to we talked about this notion of a ventilator, and this is such a timely topic relative to COVID and all the horror stories we're hearing about how people are doing in COVID. And the question is a DNR versus being on a ventilator. So I have some people that I've talked to that I've shared that I'm not advocating for this. I'm saying this is a personal decision. But my husband and I both are very conscious of what's happening in healthcare and on COVID. And we both decided that we do not want to be put on a ventilator if we get COVID because of the poor outcome. So I've talked to people about that who've asked me, since I'm a hospital administrator and have that background, and they've said, oh, I don't need to declare that in my documents because I have a DNR. And they don't understand the difference between a do not resuscitate order, which we call a DNR in healthcare, do not resuscitate, and being put on a ventilator. And they don't understand that do not resuscitate means if you have a cardiac or respiratory arrest, whether the healthcare professionals will intervene. Whereas a ventilator is not where you've had an arrest, but you're declining in terms of your pulmonary function.
Right.
And so the decision needs to be made. So could you unpack that a little bit? I know we had our documents, our living will documents changed. So could you talk about that just for Elisa, because it's such a contemporary topic.
Absolutely. I think this is one of the number one questions I've had in the last 3 months. There's no question about it. And so let's talk. You just went through a whole lot, and I'd like to unwrap that a little bit and go through a couple different scenarios and also just talk about some practical tips for what you can do to get your documents updated if they need to be to address this. So one of the questions that I love that you guys asked on the panel before we started was, does your living will address a ventilator? And you can go reread it because it really does not. It does not say anything about a ventilator, anything about a respirator. In fact, it lumps together nutrition and hydration, which drives a lot of people crazy, me included, because those are two completely different things. And Janet, you having the healthcare background, I know you're well aware, some people want to be hydrated, but they don't want nutrition. They don't want a true feeding tube. And so the living will, like I said, antiquated document in South Carolina. And we will often, I work with clients all the time, and we actually just get around it. We still fill it out, we still sign it, but we fill it out so that it's really clear. We mark through those choices and we state, please see my healthcare power of attorney. Because, and I'll say this, the only reason that we even fill it out, and I think this is important for everyone to understand, your living will in this state, based on our laws, supersedes your healthcare power of attorney. The way our law is currently written, if you did a living will in California in 1988, that's going to supersede a 2020 South Carolina healthcare power of attorney. So if you are redoing a healthcare power of attorney, please make sure that you are doing a living will here to revoke an old one or addressing that in some way. So you want to have both documents. The biggest mistake I frankly see probably in all of the review work that I do, certainly one of the biggest ones, is that people will have a living will and they will complete it saying that they do not want nutrition and hydration to be provided. And then over on their healthcare power of attorney, they will go ahead and they will appoint an agent, which is, if you've got your documents out, that'd be wonderful. You can take a look at them. That's actually option A under 7, it's paragraphs 7 and 8 on your healthcare power of attorney. So if you're taking notes at all, you can mark down, those are the paragraphs you'll look to. What the South Carolina healthcare power of attorney does that's different from the living will, it gives you 3 options. Instead of just saying, I do not want nutrition hydration, or I do want nutrition hydration, it says, I do not want it, I do want it, or scrap both of those, I'm going to appoint an agent. And then my agent, I'm giving that person discretion to make the decision for me based on my personal beliefs. Mm-hmm. It's based on several things, but I think personal beliefs are probably the most important to talk about today. So how does this work? If you filled out a living will and you've said, I do not want life-sustaining treatment, and then you fill out a healthcare power of attorney stating that you want to give your agent discretion, what have we done here? If our living will supersedes our healthcare power of attorney, we are not going to get the result we want at end of life. So please, 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 if you're taking notes or if you have healthcare documents, pull those out and make sure that those are congruent, because I see this done incorrectly all the time. I have, we've lobbied this legislature here to try to update these documents, but until it's done, until the state releases a new form, this is the way you're going to want to do it if you want an agent involved. So I say all that to move on to the issues with COVID and with the ventilator. Because neither document directly addresses a ventilator at all, I've done a lot of research, and I've also talked with a lot of other practitioners, and nationally we've talked kind of about what our documents say from state to state and how this is being addressed. If you've not addressed this by putting an agent in charge, okay, I'm concerned that you would not have the ability either way to make that decision. So how could you could end up on a ventilator, because this is, as Janet pointed out, it's being considered treatment. It's not end of life, right? And so they're not even going to get to the point of addressing an end of life decision, because this is just considered treatment. And if you don't have an agent appointed to make those treatment decisions for you, doctors are just going to go ahead and go forth with what they believe at the time is the best treatment. And as we all know, that varies from doctor to doctor. It's why we talk about second and third opinions when someone gets a big diagnosis. So 10 different doctors can have 10 different answers. scary or not, on how something should be handled and what the standard of care is. Certainly with something like COVID, this is a novel virus to everyone. And so I can see where 10 different doctors would have 10 different answers on how to treat this and what the best protocol would be, because I just don't think that it's been around long enough that we have all the answers. Janet made a great point earlier that the ventilator rates are really poor. I mean, that's what we are continually seeing when the research comes out, and that people who are placed on a ventilator are maybe not getting the best outcomes. And this is something that I think at the outset back in March, we all thought ventilators were going to be the lifesavers that we wanted them to be, and that's not what's happening. So what a lot of my clients are doing to alleviate this and how we're getting around it, a couple of things. There is a COVID addendum. I've got it. I'm happy to share it with you guys if you guys want to post it somewhere. It's just something we've put together that's a kind of a check the box yes or no on some different ideas on what you would want. But you've got to make sure that under your healthcare power of attorney, you've appointed an agent. Okay, so that's key, right? Mark box A on 7 and 8 that you are giving discretion to an agent. And then I also think that you want to make sure on your living will that you are not trumping your healthcare power of attorney with that living will. So you've then got to double back around and go look at that living will and make sure you didn't mark option, that second one, that you do not want nutrition hydration, because that's going to overrun. Okay, so let's look at that. Make sure again you're appointing the agent. The other concern that I've had, and I don't know if this is ever we're gonna get here in the United States, but I don't know with the case numbers and what's going on, but it's worth pointing out that there was a situation in Italy that we all saw unfold on the news where decisions had to start being made on who was going to live and who was going to die, because they didn't have the resources to really attend to everybody. And they're asking questions like, do you have children? Do you not have children? And they're making decisions based on things like that. There has been some theoretical discussion amongst different practitioners that if you have marked that you do not want any kind of nutrition, hydration, anything at the time of death. So on that living will and healthcare power of attorney, if you've just marked, I don't want treatment, that you would never be given the opportunity, if we were ever in a situation where life support resources were limited, that you would be someone who was not given first choice because you'd already stated that you didn't want to be kept alive. And again, we've talked about this ventilator is a very funny issue, and it's not necessarily an end of life issue. It can be considered a treatment issue. So parsing through all of this on what you want, I think, is so important. I'll wrap this up. I know that was a lot of information and kind of long, but I do want to point out that the best thing you can do, and I'll come back around on this, is make sure your agent, make sure your agent has appointment to make decisions, but also make sure that they understand what it is that you want. And the conversation is so important. I know you guys talked about this at the last webinar. Those conversations are important. I've really gotten to a point where I used to just say having the conversation was enough, but I've been through too many disputes where family members disagree at the end. And they may have heard mom or dad, but they don't remember. And so I've gone to what I'm really advising clients is, please have the conversation. Please write it down. Please write it down, sign it, date it, because if there's truly an end of life decision that has to be made, people hear very different things. And we all remember the telephone game, right? And how things make it, statements make their way around a crowd. And you can have 10 different people in the same room and everybody takes something different away from a presentation or a conversation. So I would really encourage you to take the time to write out any specific desires that you have. And I think this can be general, and I think this can be very specific. I have worked with clients who've written out 4 pages of direction and, or 4 lines. And I don't think that much matters, but having something in your handwriting or something typed out that you've signed and dated that just gives that extra information to your agents, I think is a great way to give them the ability to carry out your wishes it's still going to be a burden, but with really minimizing the burden that you're giving them to have to make a decision like that.
So thank you, Elisa, for all that. I just want to clarify, because some people may not be familiar with the terms. So when we talk about nutrition, we're talking about whether you want to have a feeding tube put in. And of course, we have these stories that have been in the news about long-term comatose patients where the family has to struggle with whether to take out the feeding tube. So the question is, do you want to put that in to begin with? That's what you mean when we talk about nutrition. And by hydration, that means whether you want an IV. Everyone knows what it means to be dehydrated. And so those are that's what we mean by those things. You know, do you want an IV done if you get dehydrated? Do you want a feeding tube put in? So I wanted to clarify that. I
And
also,
I am not obviously not a doctor, just, an attorney, but I work with a lot of clients in this area. And I understand that the hydration, even in some cases, can be ice chips.
Yeah.
I think depending on where you are. And there are certainly clients that we've had, say that it was awful to be so parched, or they felt that their loved one was really, that was a terrible situation, and they wanted them to be able to at least have some kind of something for their mouth. And so those are just different things. Like I said, I'm not a doctor, but things that I've heard from clients. And so those are things to consider.
I also want to say, I happen to serve on the Hilton Head Hospital board. And so for a lot of my friends, I've been giving them updates, and I've been so impressed because I'm on the board of hospital in Ohio, hospital system in Missouri. So I've been able to see across the country what organizations have done. And I've been so impressed with Hilton Head Hospital and Coastal Carolina's preparation for the COVID and all of their planning and readiness. They have had COVID patients, which has been reported, and treated them. And we have not been hit as hard, what we call south of the Broad, as we have north of the Broad, but the hospital has been very well prepared. So Elisa, I want to thank you again for joining us. This was a lot of information. I know this is a lot to unpack, so I want to make a couple comments. Again, we have resources on our website. We are recording this video and this video will be available on our website. Give us a few days to edit it and get it up, but this will be available. And so we want to get resources out into the community. And Elisa, you've really helped do that for us today. So thank you very much.
Thank you very much.
And so now what I want to do is I want to turn it back over to Debbie, and she's going to provide some final information and talk a little bit more. Hi, Debbie. How are you? Did you take notes?
I did take notes. That's why I was like, oh my gosh, I'm on now. I have so many.
Good. So now Debbie's going to provide us some upcoming information about some upcoming webinars. And I want to thank those of you who filled us in. I do want to have one final thought, which is, Debbie, I had a friend recently who, just in the last week, who told me that, she's in isolation with her adult children in their 20s. And she said one night at dinner, tomorrow night, I want to prepare you because we're going to have a death conversation over dinner. And her kids, who are in their 20s, like 25 and 26, were like, what? And she said, well, I want to give you 24 hours notice. Nothing's happening. Your dad and I are fine, but we want to know what your wishes are. And we want you to know what our wishes are. And so I want you to think about that. And she said they had the most intimate conversation. And the good news about that is they all heard the same things from each person as to what the wishes were. And so we really want to be stimulating people thinking and having conversations so that people are well informed about how they might have control at end of life, about what happens on their behalf. So Debbie, thank you again so much. And I look forward to seeing you next month.
Well, and Janet, I'll tell you, I think it's been great for all of us to have the opportunity to actually engage in these conversations. They're not always easy, but what I have found and where I feel so privileged to be the moderator is it certainly demystifies a lot of the things that we've all questioned and haven't known the answers to. I know that as Elisa was talking, I really was taking notes. I have a 92-year-old father who lives with me, and I'm 67. So I think they're all things I really want to do. I have to laugh, and then I'll get to my real part, is I reached up and grabbed my papers as Elisa was talking, and I can tell you I will be reviewing everything now because I do have so much more clarity. So I just want to thank everyone for taking the opportunity to join us here today on these webinars that are offered by Hospice Care of the Lowcountry. And I'm actually going to make sure that I have all of these right because we don't want to miss. Our third webinar is August the 14th. This is going to be fascinating. It's going to be on medical matters. And the Dr. Bob, who's Hospice Care of the Low Country's medical director, is going to be on, and he's extremely articulate. I think you will learn so much. He's going to be joined also by Lee Levesque, who's the captain of the Bluffton Township Fire District. And I think what's interesting, Janet mentioned before, is he's going to kind of share with us what it's going to be like to actually go through a 911 call, and maybe some things, tips or that we can learn and be prepared if you can be prepared. And then on September 11th is going to be the fourth webinar. And I'm looking forward to that too. And that's on grieving. I'm especially excited to hear thoughts on the grieving and experience. Hospice Care of the Low Country always offers free grief support at any time, and they are amazing. Barbara Scobie, who is the bereavement director, and also Charlie Taylor, the chaplain. Charlie Tyler, who is chaplain, will be joining us. Please forgive me for that. The fifth webinar will be October the 9th. And I think that's going to be an interesting one too. That's going to be about planning a funeral. In today's world, there are a lot of different options. Sherry Stahl from Low Country Cremation and Burial Services in Bluffton will be joining us, along with Valerie Mayer from Island Funeral Home. So I want to make sure we put that in our calendars also. I think that will be a really interesting discussion for many of us who really have no idea where to begin in the process. I think, again, knowledge is power. At the end of this, and we're almost at the end, there is a survey that we would really like you all to take. We really value your comments. We will listen to them, we'll take them under advisement, and I think it will help to shape webinars coming up in the future. So again, anybody can join these webinars. So please, grassroots here, share with your friends and families. It's a wonderful opportunity to talk, as Janet and Darlene and Jenny always share, to open up these conversations that once they're open are invaluable. So again, thank you all. Hospice Care of the Low Country is here for you. Again, thank you for joining us today. Please be safe, wear your masks, social distance. Thanks again. Bye.